Hello everyone, Namaste. So we are in the third week of conflict management through mediation course. In this week, we have already discussed the concept of mediation, wherein we discussed about the definitions provided by the World Intellectual Property Organization, and even we also discussed the definition which was provided in Black Law Dictionary. Along with these definitions, we also discussed about the various features of mediation, like mediation is a voluntary process, mediation is confidential in nature, mediation, like there is a refund of fees if there is a successful mediation, and various other features we have already discussed. And based on the features, when we analyze these features, we can articulately find out like how mediation is advantageous, or mediation is an effective tool for resolution of dispute when compared with other dispute redressal mechanisms that are available. So we are in the today's discussion, we will be discussing on the advantages of mediation. And as I told earlier, yes, mediation is more advantageous when compared with other alternative forms of dispute resolution. When we compare it with arbitration, when we compare it with conciliation or lok adalat, even when we compare it with civil litigation, right? And that is where how it is advantageous in nature, it can be articulate on the basis of the features which we discussed in the last session. So keep in mind that a judge's responsibility is to interpret and rule on the matters of law. In the civil courts, like the judges has given a responsibility, or what's the role of judges? The role of the judges is to interpret and rule on a matters of law. If the facts are before the judge, he will act according to the rule of law and provide a decision and judgment as per the law, recognizing the rights of the parties. Whereas in case of mediator, the responsibility of a mediator is to assist the parties in settling the dispute and be fair, equitable to all the parties if it's a binding mediation. In such circumstances, the mediator in the role of mediation will be beyond the rights, and it is great advantage. It has its own advantage when compared with the civil litigation or arbitration. Why? Is because in case of arbitration and in case of civil litigations, the judges or the arbitrator role is to decide the matter on the basis of law, and they cannot go beyond the law. If there are any other circumstantial evidence for the disagreement or the dispute that has been aroused, the judges and the arbitrator will not look into the circumstances, other circumstances which are aroused for that dispute, but it will look only on the basis of the right, the violation of the duties, or the violation of law. What's the violation of law or what's the right is, but it won't look after any circumstances under that circumstances. Whereas in case of mediation, these all parts will be discussed because it's being a voluntary process, a party centric process. The parties may consider all the circumstances whatever that were came forth in this dispute which has been discussed through this mediation. And this is how a mediation is more advantageous when compared to other. So now let us discuss this one by one with the help of the features which we discussed earlier. Yesterday we discussed that the parties will have a control over the mediation, and how the parties have the control over a mediation, we discussed it yesterday, that the parties have control because it's a party centric process wherein the party themselves discuss and the role of mediator is just a facilitative. And in that circumstances, so parties having the control over the mediation, it expands the scope of the parties to discuss whatever the dispute they have along with the circumstances, and they themselves can resolve the dispute and come up with the terms of references and issues which are limited to that, and expand during the course of the proceedings. Like, it's not only restricted to only one issue or two issues, they can even expand the issues or the concerns which they have based on the interest, based on the concerns, based on the issues parties have. And the total control of the outcome of the dispute is lies in the hands of the parties themselves, and they, on the basis of legality, they may decide whether to settle the matter or not, and even they have the right to draw the terms of settlement. And in that circumstances, having more control to the parties, there is a more chance to resolve the dispute or the conflict which they have. And that is where the crux, or how the mediation is advantageous to the parties for resolution of dispute. Even the second advantages is that a mediation is participative. Parties get an opportunity to present their case in their own words and to directly participate in a negotiation. So it's being a more participative. It's being a more participative in nature, wherein the parties themselves represent their case in their own words, and wherein the mediator facilitates. If there is any more actions, if there is a more grudges, then the mediator may calm down the parties. The mediator role is well trained enough. The mediator being well trained, he will be in a role of a facilitative, provides the parties to discuss among themselves and make them participative. And because of that participative in nature, so there is a more chance of settling the matter, and by means of negotiation. It's a voluntary process, as we have already discussed. It's being a voluntary in nature. Any party can opt out at any stage, and if he feels that it is not helping him, so in that circumstances, whereas in case of arbitration or in case of civil litigation, this voluntariness won't come, because in case of civil litigation you have to decide the matter, you have to argue the rights, wherein case of mediation, it's being a voluntary in nature, he can opt out at any stage, and even he can choose to go to the court. And this being an opt-out mechanism, the trust of the parties will build, will provide an opportunity to discuss whatever they are discussing. And even the another feature which will be act as a supportive nature for this voluntariness is the confidentiality. As mediation is a confidential in nature, like whatever that has been discussed in the mediation room, that won't be taken out, or that cannot be used as evidence before the court of law or before any matters. Under that circumstances, the voluntariness will build the trust, because whatever they discuss during the part or during the mediation process, that cannot be used. And these two principles, or these two features of mediation, will enhance the trust of the parties to come to the mediation proceedings and decide and settle the matter. Yes, it's being an voluntary, it's being and participative, it increases the speed of resolution of dispute, and that is where it's the fourth advantage of mediation is it's a speedy, it's an efficient and economical. It's economical because it's a speedy in nature. It saves the cost of various things like the advocate fees, the court fees will be saved, and that is why it is more economical. It's efficient. It's why it's an efficient because it's a party centric. There is no requirement of implementation proceedings as that of a courts, wherein if a court passes a decree we have to go for an executive petition to implement such decree or a judgment, and that is why it's very efficient because the party themselves resolve the dispute and there is a more chance of resolution of dispute. And it's an efficient is because it will be a win-win situation for both the parties, which also preserves the relationship of the parties. The procedure is simple and flexible. The mediation procedure is very simple, very flexible because it's up to the parties to decide the mode of resolution, the mode of negotiation, how they want to take place. It's an informal, it's a cordial or a conducive environment which has been provided during the time of mediation because the party themselves resolve the dispute. In that circumstances, they may opt any formal, any mechanism, any informal. They may go for joint session at any time. They may go for private sessions at any time. They can discuss the matter. They can like even go for break, and they can come back on some other day if the parties are like on a extends grudge level. Under that circumstances, the party can resolve among themselves in an informal mechanism, in a cordial mechanism, or in a conducive environment. They can choose the place wherever they want. They can sit at their home itself. And this is how the mediation is flexible, mediation is simple, it's an informal, and that is how it is advantageous to the parties. Mediation is a fair process because the mediator will act as an impartial, neutral, and an independent party, wherein his role is only assisting or facilitating, wherein he can't provide any views, any suggestions, but he he is trained enough to provide a participative environment or a conducive environment for the parties to resolve the dispute among each others, and he is helping the parties to calm down and focus on the interest. He is requesting the parties to focus on their concerns, on their needs, desireness, and helping the parties to prioritize the same and reach to an amicable settlement. And being it's already I have discussed the feature of confidential, how confidential and voluntariness will work on a simultaneous basis, which will be an advantageous to the consumer to build a trust, wherein the parties to have trust in the mediation process. The confidential nature will act as one of the important feature of the mediation, that the confidential, that whatever that has been discussed in the mediation room won't be taken it for any other use or any other purposes. It cannot be used as an evidence in a court of law as well, and that is where the parties will open up their mind to discuss and resolve the disputes. The process facilitates better effective communication between the parties, which is crucial for creative and meaningful negotiation. Mediation helps to maintain, improve, restore relationship between the parties. Yesterday we seen an example of an orange case wherein we all got to know that like one wanted the orange pulp and one wanted the orange rind, wherein if you discuss the same thing on the basis of the needs and the concern or the desireness, if the parties discuss on these lines, then the parties will get to know what actually they wanted, and on that basis, if the matter is been resolved, say for example in case of orange, if one person gets the rind which he wanted and the one person gets the pulp for making of juice, so both will be satisfied. and both will be on a win-win position maintaining the relationship. Because, and even in case of the other horse case, wherein both ate all the feed which is available over there, and if they were in a case, if they are fighting to reach at their own field, it would be very difficult for the horses to get feed, and they may lose, there might be certain things wherein they may lose something. And under that circumstance, if the court has to decide such matters, what the court would have did, the court would have break the rope in between, and they may let go both the parties to eat their food which has been provided to them on the basis of the right allocated to them. In that circumstances, the relationship would not have maintained, because one will go on the other side and the other will go on the other side, and that is where the relationship would have like breakdown. And that is how the crux of mediation, if they both together discuss, settle out the matter, they go. That is what the example of a horse showed. The last session's example which I am talking about, that they both went on the one side, they ate both together, they ate the both the fields. So this is how the relationship will be maintained, and they both are happy. And this is how the mediation is advantageous. The mediation always takes into account the long-term and underlying interest of the parties at each stage of the dispute resolution process. In examining alternatives, in generating and evaluating options, and finally in settling the dispute with a focus on the present and the future and not on the past. This provides an opportunity to the parties to comprehensively resolve all their differences. So basically, when the dispute resolution takes place through mediation, the focus will be on the present and the future. Because in most of the circumstances, take for an example, if it's a consumer dispute wherein manufacturer came up with a product and the product is defective and it was been purchased by a consumer, and because of that defective product the consumer is been injured and he needs a compensation for such defective product which has been manufactured by the manufacturer. If at all a court decides, the court decides in a manner like it's a defective product and the manufacturer will be directed to provide compensation for a victim. In that case, the victim will think that I will once again not purchase the product of the manufacturer because he produces a defective product. Even because of this judgment, the manufacturer will lose the credibility. And in that circumstances, if at all the matter has been settled through mediation wherein he will provide the compensation what actually the consumer need, and it will create an environment wherein the consumer, the victim, will ask, please don't manufacture these types of defective product, and he agrees for that, and henceforth because of the credibility of the manufacturer he will even look after the manufacturing process wherein the defect is been lined with, and he will try to come up with such standard product wherein it increases the credibility of the manufacturer, and even the consumers are been satisfied with such products. And this is where the crux of the mediation will lie. Even there are n number of examples which we can take wherein the mediation will focus on the present and on the future. And because the relationship is maintained between the manufacturer and the consumer will again go to that manufacturer itself to purchase such products. And further, in mediation, the focus is on resolving the dispute in mutual beneficial settlement. And it is a mutual beneficial settlement is because the parties themselves settle out their matter, and which is mutually beneficial because both the parties has to agree and reach out to an amicable settlement. That is why the mediation is made for. And the mutually beneficial settlement in such a way that I would like to provide a good example wherein there is a one doctor who committed a negligence, and because of that negligence the patient lose the right leg, wherein he was not able to walk as well. And in such circumstances, so if at all a patient goes for a court, what he will receive? He will receive at the max, he will receive the compensation to the lost leg and even the pecuniary damages. What if? What further then? Whether because of his broken leg he won't work, he won't go for a work, wherein all these family members are dependent on him. If he works, then only he will earn certain bread and butter for his family. Under that circumstances, what if a mediation takes place for this dispute, wherein he can seek a job from a doctor, wherein if wherein he can be an employee of that hospital itself and earn something for his livelihood, which can be, he can also get the compensation during the mediation process and even for the pecuniary. Along with that he will also receive something or some job for his family holders or some job for his own. And this is how it can only be happen in case of mediation while discussing between them. And this is how they will reach to a mutual beneficial settlement. And mediation process will provide this mutual beneficial settlement and making it advantageous for the people, and it will be an effective resolution of dispute. Another important factor that is more advantageous in case of mediation is that the mediation process will settle the related and connected cases between the parties, and mediation allows a creativity in dispute resolution where the parties can accept the creativity and non-conventional remedies which satisfies their underlying and long-term interest, even ignoring their legal entitlements and liabilities. As we have already discussed with few of the examples like the horse case, wherein if at all it has been settled through a court, what would be the legal entitlement would be that the legal entitlement is that the field which was been allotted for horse A, it has to eat that part, and the field which was been allotted to part B was to get that. And here we are differing from the legal entitlement that both together can eat each part, both the parts, and can enjoy happily. Even in case of orange case, what was the legal right? If at all, in case, what would be the legal right if one orange has to be distributed between the two? It would have been, we would have cut it in two parts and distributed half to the both the parties. But actually, as per the legal entitlement, they would get the half part each. But but when we resolve that dispute by means of mediation, we are deviating from the legal entitlement, wherein we are looking after the desireness, the interest of the parties, the need of the parties, and that is where it has created more advantageous for both the parties and came to an amicable settlement wherein one who needed the rin and the one who needed the pulp, both of them got what they needed and they are happy now. And this is how we are deviating some from the legal entitlement and creating a creativity dispute resolution. Along with that, when the parties sign themselves on the terms of settlement satisfying the underlying needs and interest, there will be a compliance and there is no need for any executive petition further. Mediation promotes finality. The disputes are put to rest fully and finally, as there is no scope for any appeal or revision or any further litigation. And that we have already discussed with the help of two cases as well in the previous session. Like mediation, if there is a successful mediation, then the parties cannot appeal, they cannot file any revision, or there cannot be any further litigation on such disputes. Refund of court fees, if there is a successful mediation, the court will refer. In case of court referred matters, the court will refund all the court fees which has been paid by that in the particular case. With this, we here conclude that the mediation is very advantageous when compared with other two mechanisms or other mechanisms that are available for resolution of disputes. I use two mechanisms is because a court is the adversarial mechanism, and on the other part the non-adversarial mechanism, that is the other types of alternative dispute resolution, that is arbitration, conciliation and lok adalat. When we compare all these mechanisms with mediation, the mediation is more advantageous. With this, I conclude today's session. Thank you.